Good afternoon once again, and welcome back to the virtual VETS'20 webinar series. Today is part 4 of our 14-part webinar series, hosted by the National Veteran Small Business Coalition. I'm Earl Morgan, NVSBC Program Director. And to our new attendees, thank you for joining us today. Again, we'd like to thank our 8 sponsors who made this webinar series possible. Today's webinar runtime is about an hour, and this webinar is recorded. If you have any questions, please send them to scott.dennison@nvsbc.org. We will try to get to all the questions on this webinar, and if we run out of time or miss your question, we'll have it posted on the NVSBC VETS'20 replay website. Now let me introduce the Executive Director of the National Veteran Small Business Coalition, Mr. Scott Dennison.
Thanks, Earl. Good afternoon, good morning to everyone, depending on what part of this great country you're in. Thanks, Earl, for doing all the technical stuff to make this thing happen. And special thanks to all our sponsors. We couldn't do this without them. They've been a tremendous blessing to us. So welcome. This is an exciting series for us, and we've got a really good topic today. And not only we have a good topic, but we've got a great presenter. So let me introduce you to Maria Panichelli, the partner and head of the government contracting practice of the law firm of Obermeyer, Riedman, Maxwell, and Hippel in Philadelphia. And her practice is focused strictly on government contracting, works with an awful lot of small businesses. Maria has been a star supporter of the NVSBC since we started, and continually comes to the VETS conferences and speaks and always gets high marks. And like I said, this is a hot topic for people in government contracting. So we invited Maria to join us today, and she graciously accepted. So we're thrilled. Maria, thank you. And with that introduction, we'll turn it over to you.
All right, thank you so much for that lovely introduction, Scott, and thanks to VETS for having me and for Earl to putting everything together. Last but not least, thanks to all of the attendees out there for joining us today. Today we're going to be talking about what not to do in bid protests, and we'll be going over some of the most common mistakes and misunderstandings. Next slide, please. So here's a little preview of today's agenda. We're going to be talking about a little primer on the fundamentals. I think even those of you out there who have been involved in a protest or know your stuff in terms of government contracting, there seem to be some, I guess, fundamentals that not everyone is entirely up to speed on, and it might be because you've never done a contract under one particular part of the FAR before, or you've never done a protest that arises under a certain type of protest before. So I think it's always a good place to start doing a primer on the fundamentals to make sure we're all kind of in the same boat and on the same page with the basics. And then we use those basic building blocks to expand from there and kind of learn the more complex concepts. So from there, we're going to go into where you file a bid protest. We're going to talk about the difference between pre-award protests and post-award protests, and that's a really big one that we see people make mistakes. Kind of in connection with that, we're going to talk about what the competitive range is and what happens when there's a competitive range procurement and how to be aware of the deadlines that might come up there and kind of your jumping off points or your quote unquote trigger moments when you've got a competitive range procurement. Then we're going to get into what I call the riddle of the required debriefing. A lot of people have a lot of misconceptions about when debriefings are required and when debriefings toll their protest deadlines. It's a big mistake we see people make, so I want to tell you what it is so that you don't make it yourself. We're going to just do an overall sum up of miscalculation of deadlines and understanding how not to do that, how to make sure you meet your protest deadlines. Then we're going to talk about debriefings again, but specifically what goes into a debriefing and how to take advantage of your debriefing, what you can ask, what you can't ask. And we're going to talk in line with that a little bit about the DoD enhanced debriefing deviation. We're going to talk about how to spot a winning protest versus a losing protest, how to figure out which ones you want to pursue versus which ones it might make sense to let go. Finally, we're going to talk about bid protests versus size and status protests. And then we're going to do one last piece. We're going to kind of look on the flip side and think about what happens when you're not the protester, but you're the awardee and your award has been protested. And we're going to talk about how you intervene. Next slide, please. So with that, let's jump right in and talk about the first mistake. And that mistake is don't forget the fundamentals. Next slide, please. Starting from, the fundamental building blocks of what you need to understand when you're talking about bid protests, the first thing you need to be aware of is the governing law. Like most things in government contracting, the Federal Acquisition Regulation, or the FAR, is kind of the seminal source, the starting point, the jumping off place for most of the rules and regulations that are governing the FAR, the protest process. It also is going to govern the procurement process that you are going to be protesting. So a big piece here is to understand, hey, look, not only does the FAR govern the process the protests are going through, but it's kind of what sets up the framework and tells you what the government might have done wrong, and that's what your protest is based on. So the FAR and the Supplemental Agency Acquisition Regulations, are going to be important for both of those reasons. Oftentimes, also contracting related statutes such as SECA or the Tucker Act, or the VETS' come into play as well. And then if you're dealing with a set aside, oftentimes, there can be some small business regulations, either the ones promulgated by the SBA or sometimes the Department of Veterans Affairs, that are also going to come into play and also could impact the arguments that are kind of at issue in the protest. Now, this is not technically quote unquote law, but it's also going to be something that's relevant to protests. And that's going to be the terms of the solicitation itself. So whenever you're talking about a requirement at a protest of the source selection decision in connection with the requirement, the terms of the solicitation are going to be really important. And as long as those terms are consistent with the FAR and with the other government contract related law out there, they are going to govern, and they're going to govern that process that the government should have used to go through the source selection process. So obviously that's going to be something that's very important for purposes of establishing, a protestable basis to challenge the award decision. Next slide, please. So next thing you have to think of in terms of basics and kind of the fundamentals are you need to understand that there are some critical considerations that can kind of change the trajectory of a protest or impact what's going to be at issue or how certain issues are approached. The first question is, who are you dealing with? Is this a one agency procurement, or are there multiple agencies involved? Is it a GWAC situation or some sort of IDIQ where you can have one agency putting task orders under another agency's IDIQ or GWAC rather? Is it a situation where one agency is procuring a service on behalf of the other? Are two agencies cooperating? And what role is the agency playing? This is going to impact a number of things, including if it's a task order protest, whether or not you have jurisdiction. And we're going to get into all these things in more detail later. But for now, I just want you to be aware these are the critical questions you need to ask, you need to discuss with an attorney to make sure you're kind of putting your protest on the right track, in the right lane, in the right bucket, etc. What method of procurement is being used? Is this a FAR Part 14 sealed bidding scenario? Is this a contract that's being procured under FAR Part 15 through contracting by negotiation? If it's contracting by negotiation, is there a situation where the government has put in place a competitive range or LPTA? And again, these are concepts we're going to talk about in more detail in today's presentation. These things are going to impact the evaluation scheme, whether it's price as the most important factor or whether there are non-price evaluation factors. It's going to impact whether or not there are different phases of the procurement process. It's going to impact whether or not debriefings are required. So again, what method of procurement is being used, really important to get your fingers around and talk about with an attorney if you've got questions. And finally, what type of contract is at issue? Is the contract an IDIQ? Is it a set-aside contract? If it's a set-aside contract, is it for hub zones or women-owned, etc.? What about if it's a task order? What if it's a task order under a GWAC? These are all questions that are going to impact kind of the rest of the things we're talking about today. So for now, just keep in mind these are the questions that you should have milling in your head, and we're going to talk about why they become relevant throughout today's presentation. Next slide, please. So final thing in terms of the fundamentals, you want to make sure you understand the timeline. First thing, obviously, is that the solicitation gets put out on the street. whether it's an RFP, an IFB, an RFQ, et cetera. And that's going to depend on, what part of the FAR you're under. Sometimes there's going to be Q&A, and that's your chance to, ask the government questions about what's going on with the solicitation, any questions or ambiguities you see. Then obviously responses to the solicitation are going to be submitted, whether it's a bid or a proposal or a quote. If you are in a FAR Part 15 situation, contracting by negotiation, there might be something called the competitive range. And we're going to talk about that in more detail later, but this is the point at which the competitive range would be selected and then discussions would be initiated. There will be notices that are sent out at that point. And we're going to talk about what they trigger when we get to the deadline section. You then go into the evaluation process and the source selection and award decision. You might get pre-award notices if it's a set-aside project. Then you go to award, and then you get the post-award notices. So keep this timeline in mind as we're going through the specifics of the mistakes that we're handling on the rest of this presentation. Next slide, please. So let's start with a pretty simple mistake. We're going to start small and then build to the more complicated concepts. The biggest mistake we see in this area is that people file in the wrong place, or they think that they are supposed to file protests in a different place than they are. Next slide, please. So unlike, breach of contract actions or, ways that you file lawsuits in other types of disputes, if you are used to dealing with local government or if you are used to dealing with a private contract, protests are not going to go to normal, everyday quote-unquote courts. They're not going to go to your state court. They're not going to go to your local U.S. district court. Protests are heard and adjudicated for the most part in 3 places. You can file a protest with the contracting officer. That's an agency-level protest. You can file with the GAO, the Government Accountability Office, or you can file with the Court of Federal Claims, COFC. Now, every attorney probably has different personal opinions on where to file protests and what's best. Personally, I will not say that I speak for every attorney when I say this, but personally, I have found, in my experience at least, that filing with a contracting officer can be helpful when it's kind of an administrative or clerical error, where you're pointing out an error that's pretty simple, like, hey, you transposed these 2 numbers, or you added this wrong, or somebody seems to have left this paper out, and that resulted in a mistaken award decision. And if you just correct that really simple mistake, you can see we should have gotten the award. That's where I see a lot of success at the contracting level, the agency protest level. Other than that, I think if you actually get into procurement errors, I have found, again, I don't purport to speak for everyone, but I have found that generally speaking, if you're getting into, hey, no, I think there was a substantive error in the award decision, you're going to want to go to the GAO or to COFC. Generally speaking, GAO is going to be more affordable than COFC, and we're going to talk more as we go forward about some differences between the two. But when you're dealing with GAO, you're going to be dealing with agency counsel defending the protest. When you're dealing with Court of Federal Claims, you're going to be dealing with DOJ defending the protest. So there are some differences. If you have a protest and you're working with an attorney to file one, you're going to want to talk to them about the benefits and drawbacks of, where should we file this and what the differences are and what's best in my situation. But you've got to be aware that these are the bodies that you file with. Sending a letter to the contracting officer that's not styled as a protest is not going to be considered a protest. Sending a letter to the GAO that's not filed through what they call the EPTS system is not going to be considered a protest. And filing a lawsuit in district court or state court or many of the other places that I've seen contractors mistakenly try to initiate protests isn't going to do it. You've got to go to one of these 3 bodies and you've got to use the established quote unquote protest procedures. Next slide, please. All right, so now let's move into some of the more substantive protest mistakes. The first one that we're going to cover, and this is one that, lots of contractors, even contractors that have been doing business 25, 30 years, sometimes make mistakes on. And this is that you don't want to mix up post-award protests and pre-award protests, and you definitely don't want to mix up the deadlines associated with them. Next slide, please. So I think the threshold thing that you want to keep in mind is we just talked about the different places that you can file a protest. Deadlines are different from place to place. But for the most part, we're going to be focusing today on the GAO deadlines. The reason for that being you actually have a little bit more wiggle room. You have a little bit longer of a time to bring a protest before the Court of Federal Claims. And as a general matter, if you get your protest in within the deadlines applicable to the GAO at the contracting level, you're good. So the easiest way to kind of think about the deadlines is to think about them in terms of the GAO deadlines so that you can plan accordingly for the GAO. And then if you need to adjust from there, you're in good stead to do so. It's kind of the safest thing to plan for. So many contractors believe that they're familiar with, what they think the general rule is. And they'll spout something off to you like, I know, the protester has to file its protest within 10 days of the basis of the protest being known, or, whether it should have been known. And I know it's whichever is earlier. But that is not accurate in all situations. And pre-award protests are one of the situations where that is not accurate. Next slide, please. The rule is different for pre-award protests. And if you're protesting, and we're going to talk on the next slide about what some of these issues could look like, but if you are protesting, hey, look, I think there's something wrong with the solicitation itself. I think the terms of the solicitation are messed up and should be changed, and then we'll all be able to bid on this fairly. That is not 10 days within the time that you should have known the protest. That doesn't mean 10 days after award. It doesn't mean 10 days after your debriefing. Protests like that need to be brought before the deadline to respond to the solicitation. So if the solicitation drops August 1st and you've got to respond by September 15th, you are not going to want to respond, roll the dice, see if you get the award, and then if you don't get the award, go, oh, all right, well, now I'm going to go back and say, hey, there was something wrong with the solicitation. If you wait until that point, you will be out of time. That will be an untimely protest. You need to get your protest in before the deadline to respond. And if you think about it, that makes sense, right? Because the idea is the government should be given the chance to consider your protest and say, oh, yeah, you know what, we need to amend the solicitation. They're right, we did this incorrectly. And then everyone's going to be able to bid or, submit a proposal or quote, et cetera, on the new amended solicitation. That's going to save everybody time and save everybody effort. You're not going to be able to roll the dice, see if you win, and then protest something that was wrong in the solicitation. So, next slide, please. What are some of these issues that I'm talking about? Because, you might be out there saying, okay, that's great in theory. I know that, I need to file a protest based on the terms of the solicitation early. But what does that look like? What are some issues that would fall into this category that I know I need to bring up early? Well, if you're saying, hey, look, I'm looking at the solicitation and there are ambiguous or contradictory terms in here. You've got something in the statement of work that's inconsistent with the specs, or you have something in the evaluation criteria that's inconsistent with something else in the evaluation criteria. You have something that conflicts with another section of the solicitation. In other words, anything that is either susceptible to, kind of a vague or unclear meaning, it's ambiguous, or anything that you think is in conflict or contradictory in the solicitation, you're going to want to clear that up before you submit your bid or your proposal. This is one of those things that you might be able to deal with through the Q&A if the government's letting you do a Q&A as part of the, the bidding process. If not, this is a potential basis for a pre-award protest. Also, they're in the FAR. There are certain times that FAR clauses need to be included in procurements. There are certain times that they're absolutely not supposed to be included in certain types of contracts. If you see that the contracting officer has perhaps made a cut and paste error and there's something in there that's not supposed to be in there that could negatively impact your ability to bid or submit a proposal on the project, or if you see that they've left something out that, would really give you a leg up, that's another pre-award protest basis to say, hey, look, this should be in there or this should not be in there. And you've got to amend the solicitation to take out the term that's not supposed to be there or to put in the term that is supposed to be there. Unduly or overly restrictive terms is a big one. And that is where you've got a situation where the government has kind of narrowed the competition in some way that doesn't really seem reasonably related to the purpose of the project. So in other words, we won one recently where, it was a construction project and the government had narrowed the past performance experience to you have to have experience building a hospital. Okay, that might be fair. Hospitals are a little bit different than, other construction projects. It needs to have been in this geographic area. All right, getting a little bit less reasonable, and it has to be within the last 3 months, and it has to have been dealt with by this particular, VISN of the VA. That's a little bit overly restrictive. There's no reasonable reason or, no rational explanation for why experience for another VA visit or experience in the last 6 months as opposed to the last 3 months is any less valuable than, experience that falls within those criteria. So we help the contractor say, hey, look, I've got experience that would be really great, but doesn't fall within those criteria, but that's a really arbitrary line for the government to be drawing. So we want to file an unduly or overly restrictive pre-award protest based on a problem with the terms of the solicitation. So that's another pre-award protest that you'd want to bring before the solicitation responses are due. Other big ones: improper use of LPTA. LPTA is lowest price technically acceptable, and I'm sure many of you have PSTD just hearing that term. It's not a popular method of procurement amongst contractors. Well, the government recognized that, and after many, many years of complaints, and unfortunately, nonetheless, despite the complaints, increasing use of LPTA procedures by the government, they've changed when the government is allowed to use LPTA, and they have put certain restrictions on it. Unfortunately, not every contracting officer has been made aware of that, and there might be times where you get a solicitation and you see that they're using LPTA, and you're aware that they're not supposed to be doing that anymore. That is, again, something that's a term of the solicitation, something that you want to protest up front. Finally, set aside rules. Rule 2, kingdomware, all of that good stuff. Anytime that you think something should have been set aside and it wasn't, or shouldn't have been set aside and it was, that's a term of the solicitation. You need to protest that before you respond to the solicitation. And finally, sometimes if you are a small business, which I know many of you guys out there are, sometimes if the government kind of bakes in pass-fail requirements, if you see anything that kind of looks like a pass-fail test, especially if it deals with things that are normally a responsibility determination, there's an argument that that is a de facto responsibility determination and that the government should be going to the SBA for that and not making it an evaluation criteria. That is another basis for a pre-award protest. So any of these items, don't wait and bid and roll the dice and see if you win and then think you're going to be able to protest it later. You are not going to be able to protest it later. These need to be brought early. Next slide, please. So the other thing that I want to talk about in terms of pre-award scenarios, are there any other situations where the post-award rules, that regular 10-day rule that we're going to talk about a little bit later? Obviously, now we've talked about, all right, there's issues with the solicitation. I know when I need to protest that. That's way early. That's before I respond to the solicitation. What about other pre-award scenarios where you don't want to wait until 10 days after an award? That's where the competitive range comes back in. Next slide, please. So what is the competitive range for those of you who are not familiar? It's something that comes up in FAR Part 15 procurements sometimes. And by that, I mean it's not in every FAR Part 15 procurement. Usually the agency leaves itself option to use it or not. And what it is that the government leaves itself the option to, all right, I've put the solicitation out in the street. I've got a lot of offerers that have now submitted proposals, and we're going to go through the award process. FAR Part 15 is contracting by negotiation, which means that they're going to specify in the solicitation, the agency, that is going to specify in the solicitation, the non-price evaluation factors and the price evaluation factor and the relative importance of those factors. And the government has left open their option to say, all right, we've got 15 proposals. Let's consider them, let's rate them, let's rank them, and let's make an award. But they have reserved their right to say, we don't love any of these. We want to do what's called opening discussions to try to negotiate with the best of these 15 to try to get something that's an even better value for the government. So they will leave themselves the option to select a quote-unquote competitive range, the best of those 15. Maybe it's 10, maybe it's 12. And they'll say, hey, 3 of you or 5 of you, you didn't make the cut. You're being excluded from the competitive range. And with the rest of these guys, with the 10 that made the cut, we're now going to conduct discussions. We're going to tell them the weaknesses in their proposal. We're going to let them revise their proposal, and then we're going to make an award on the basis of how we rate and compare the revised proposals. So the key that you need to keep in mind in terms of the protest context is when you've got a competitive range situation, if you are one of those people that doesn't make the cut, if you're one of the 5 that gets a notice saying you have been knocked out, sorry, we're going forward with these other 10 guys, we're going to have discussions with them, You are not in the competitive range. You've been excluded. Thank you for playing. Go home. Have a nice day. That is the time to act. And we're going to talk about how you go from there. And what you're going to do from there is request a debriefing. And we'll talk about that when we get to the debriefing section. But what I want you to be aware of at this point is, like the other pre-award protests, this is not a situation where you want to wait all the way till the end of the procurement process and then try to say, hey, I should have never been excluded from the competitive range. You need to start the ball rolling when you get the notice that you've been excluded. That's your trigger point. So don't wait. Competitive range makes things, again, a little bit more of a pre-award situation as opposed to a post-award situation. Next slide, please. So don't ignore the rules of the required debriefing. Let's move on to the next slide, please. So we talked a little bit about the deadlines, and I talked about, everyone thinking that they know that general rule. And that general rule is that protesters have to file the protest not later than 10 days after the basis of the protest is known or should have known. And remember, we just talked to the exception about pre-award protests based on errors in the solicitation. But what a lot of people think is the general rule, a lot of contractors you talk to say, oh yeah, I got to file within 10 days of my debriefing. And that's right, but that's right only in certain circumstances. And that's actually an exception to the general rule. So the way that the regulations are worded, and this is, again, we're talking about the GAO deadlines because those are the ones that are kind of the most common and the safest to gauge by. And their regulations are found at 4 CFR 21. But the regular rule is that you have to protest not later than 10 days after the basis of the protest is known or should have been known. However, if you've got a situation where a debriefing was required and timely requested, then the deadline is 10 days after the debriefing is concluded. So most people are familiar with the 10 days after the debriefing rule, but they don't realize that that's actually an exception to the general rule. That only applies, that 10 days after your debriefing only applies if the debriefing was, number one, required, and number two, timely requested. If you don't fall into those categories, if your debriefing wasn't required or it was required but you didn't timely request it, you're going to be under the general rule, 10 days after, the basis of the protest is known or should have been known. So what that's generally going to mean is 10 days of the award date or the announcement or whenever it was posted, etc. The only time you're going to be counting from the debriefing is, again, when it's required and timely requested. So let's talk about each of those things. When are debriefings required? Next slide, please. Debriefings are required when you are under FAR Part 15. So remember at the beginning I said some fundamental considerations that you want to be thinking about when you're talking about protests. Fundamental consideration number one, what part of the FAR is this under? That's going to impact a lot of things, one of them being, do you have the right to a debriefing? Is a debriefing required or not? So if you are under FAR Part 15, contracting by negotiation, then you are going to have a required debriefing. If you ask for a debriefing, the government has to give it. The other time that there is a required debriefing is if you are under FAR 16505B6, which is an IDIQ task order issue, and it's a task order or delivery order over $5.5 million. Now, keep in mind that the NDAA 2020 told Congress that they need to change these regulations and require a debriefing for any task or delivery order over the simplified acquisition threshold. So that's going to be changing. It's not going to be 5.5 million and up. It's going to be simplified acquisition threshold and up soon. And that and FAR Part 15 are the only times that debriefings are required. Next slide, please. Debriefings are not required for anything under FAR Part 8, that's the general service, GSA schedule, procurement, FSS schedule, etc. They are not required for sealed bidding acquisitions under FAR Part 14. They're not required for commercial item procurements under FAR Part 12. They're not required for simplified acquisition procurements under FAR Part 13. Now, two notes here. Just because you request a debriefing and the government gives you one, that doesn't mean it was required. And just because you request something and the government calls it a quote-unquote debriefing doesn't mean that's actually what you just got. Under FAR Part 8 and under FAR Part 13, the government doesn't have to give you a quote-unquote debrief, and we're going to talk about what you get and don't get in a debrief a little bit later. But they are required to give you something called a quote-unquote brief explanation of the basis for award when the award was made, at least partially based on non-price evaluation factors. So sometimes I'll see customers or clients come to me and they'll say, hey, I requested a debriefing and I got this, and, I know I have 10 days. Well, you look at what they got, and they got a brief explanation, which would indicate that it's a FAR Part 8 procurement. There wasn't a required debriefing, and they don't have 10 days from the day they got that quote-unquote debriefing, because, again, it's not a required and timely requested debriefing. That means you're not under that exception where your deadline is 10 days from the debriefing. You're instead under the general rule, which means you're 10 days from the award date or the announcement, etc. So don't confuse a quote-unquote brief explanation under FAR Part 8 and 13 in particular, with an actual debriefing. Also, you might ask for a debriefing. Let's say it's a FAR Part 14 procurement, and that's a sealed bidding situation. So let's say after bid opening, you ask for a debriefing. The government might give you one. They don't have to. It's not required, but they might be nice, and they might say, okay, we'll tell you why we didn't give you the award. Here's the information. That is still not a required debriefing, and therefore it still does not toll the deadline. So be very aware when you ask for a debriefing or when you get a debriefing of not falling into the trap of assuming that that means you've got 10 days from that day to file your protest. You only have 10 days from that day if it was a required and timely requested debriefing. Otherwise, you're going to have 10 days, and that 10 days is going to start ticking a lot earlier than you thought. If you've got questions about this, again, it makes sense to talk to an attorney that is familiar with government contracting and with procurement and protest decisions in particular. Now, one thing I want to note, sometimes a lot of you, especially if you've got like commercial items contracts, there are solicitations that kind of are interesting hybrids where they're under one section of the FAR and they kind of implicate or use FAR Part 15 procedures. They might have a clause in the solicitation that indicates that they're going to give a debriefing and that a debriefing is required, etc. That's definitely something that you're going to want to talk about with an attorney. Those cases are very, very fact specific, and when the deadlines are is going to determine or is going to turn on a lot of the facts and the way that the solicitation was set up and whether or not there was certain language used. It can become a very, very tricky proposition. So be aware that this can be a complicated question, but generally speaking, the rules are it's only required if you're FAR Part 15 or if you're a task order over 5.5 million, soon to be task order over the simplified acquisition threshold. Next slide, please. So remember I said there's two prongs to figuring out when that 10 days from your debriefing applies. First is it a required debriefing? Second is it a timely requested debriefing? So what is a timely requested debriefing? When do you need to submit your request for a debriefing in order for it to be considered on time? That's going to depend on where you are in the timeline. Remember, we talked about the timeline up front, and there's really two times that are going to be applicable. Either when you figure out that you were not given the award and you get the notice about that, or when you were excluded from the competitive range, which you'll remember we talked about a few slides back. So let's take them, at one at a time. So let's say you go through the entire the entire procurement procedure. The solicitation dropped, you submitted your proposal. This is a FAR Part 15 procurement, so it's a required debriefing, and you're going to get a notice called a post-award notice or an unsuccessful offer letter or notice to unsuccessful offerers. There's different language that different agencies use, but they're all the same thing. And that notice is going to lay out the fact that you did not get the award. Thank you very much, for your proposal. We appreciated it. We found that, this other person provided best value, and we're sorry to tell you you didn't get the award, but we appreciate you submitting, and we hope that you, continue to look for opportunities with us in the future, et cetera, et cetera. The notice has to state the number of offers that were solicited, the number of proposals that were received, the name and address of each of the awardees. So if there's one awardee or if there's multiple awardees, you're going to know each one of them. You're going to know the items, quantities, and stated unit prices of each award. And in general terms, the agency is supposed to put in this unsuccessful offer letter the reason why you didn't get the award or why your proposal was not best value or was not accepted. So I have seen anywhere from paragraphs long explanation that lay out basically the information that you would get in a debriefing in terms of why your solicitation response just didn't stack up to your competitors. And I've seen one sentences where, you didn't present the best value and the awardee did, period. It's really going to depend on the agency that you're dealing with. But this notice is going to be your jumping off point to request a debriefing in a FAR Part 15 post-award situation. Next slide, please. Specifically, what does this trigger? When you get this notice, when you get the notice of unsuccessful offerer, you have 3 days to request in writing a debriefing. If you do that, then you have timely requested a debriefing in this context. Next slide, please. So what about if you are in the pre-award category in that competitive range situation? Remember I said way back a couple quote-unquote mistakes ago that you don't want to wait in a competitive range situation until the end of the procurement process and then try to say, hey, I shouldn't have been excluded from the competitive range way back when. Nope, you're going to want to act a lot sooner than that. And you're going to want to act when you get that pre-award notice that you have been excluded from the competitive range. Again, that idea that, hey, 15 of you responded, we picked the best 10. I'm sorry you weren't part of that 10, and we're not going to be going forward with you. You have been excluded from the competitive range. That notice is going to specifically say that the contracting officer has excluded you from the competitive range or otherwise eliminated you from the competitive range and from the competition overall. It's going to state the basis for that determination. In other words, you just didn't select the best value, or you were deemed irresponsible, et cetera, excuse me. And then it's going to tell you proposal revision will not be considered, because remember, they're going to be considering proposal revision for those who were selected. That is your time to act. Next slide, please. So again, like the notice that you get post-award, if you are excluded from the competitive range, don't put this in your file and say, okay, when we check, SAM beta later and figure out who got the award, we're going to protest. No, if you think you've got a basis, you've got to go forward with it now. You want to get your debriefing now. So if you get one of these notices, the pre-award notice from exclusion from competitive range, again, you have 3 days from this notice to request your debriefing. Next slide. So you'll notice that a lot of what we've been talking about for the last section of this has dealt with deadlines. And that's because deadlines are the really, really important question in protests. So next slide, please. Let's sum up what we know so far. We know that pre-award protests based on solicitation errors, you don't want to wait. Those need to go in before the solicitation response. We know that the general rule is everything else, if it's not a pre-award protest based on the errors in the solicitation, you've got 10 days from the day you know or should have known about the basis of your protest. Now, we know that there's an exception to that when there is a required and timely requested debriefing. And in that case, you get 10 days from the day of your debriefing being concluded. We know that otherwise you get 10 days from usually the award date or the announcement of the award, etc. But let's add a new wrinkle, and that is the automatic stay. Many of you don't want to, if you file a protest, let the awardee go forward with performance while the protest is being litigated. Now, protest litigation moves a lot faster than other litigation. It's going to move, within 100 days if you're at the GAO, and probably around the same amount of time if you're at the COPC, depending, and probably the same amount of time, if not less, if you're at the contracting officer level. But what if you've got a project that, if the awardee starts performing, a substantial amount of the work is going to be done before you get the award overturned and you can take over? Or what if it's a construction project and, you don't really want them breaking ground and starting to build things while you decide whether or not you should have gotten the award instead of them? That is when you want something called a stay. A stay is basically a big pause button. What a stay does is say, okay, everything on this track of procurement with this requirement needs to stop while we figure out if this person should have gotten the award or if the protester is right. That is a very, very valuable tool. And if you file at the GAO, there's a way to get a stay automatically. And that specifically is if you file within 5 days. So we've been talking about these 10-day protest deadlines: 10 days from the day you knew or know the basis of your protest, 10 days from the award date, 10 days from the date of your timely debriefing, your required timely requested debriefing. If you want the automatic seek a stay before the GAO, you get it automatically, as the name would imply, if you file within 5 days. So 10 days to be timely, but if you're super quick and you get it in within 5 days, you get the automatic stay. Don't mix up the fact that 10 days is the automatic stay. A lot of people think that 10 days is the deadline for everything. It's not. If you want the stay, you have to be even quicker. And that is 5 days, not business days. So if you've got some questions about, oh no, the 5th day falls on a weekend, it's not going to necessarily revert to Monday the way a lot of deadlines work. You might actually have to get it in even quicker and really, really move to get a protest submitted. If you're talking about COFC, there is no such thing as an automatic stay. So deadlines aren't impacted if you go to COFC, but the downside of if you go to COFC and you're trying to stay the procurement is that there's a lot more paperwork, therefore most likely a lot more legal fees involved in trying to argue for a stay, because you basically have to ask for it like you would ask for any other injunction, which requires a motion for a temporary restraining order, motion for preliminary injunction, memorandum of law in support of those things, et cetera, et cetera. So most of the time, protesters that want to stay are going to want to go to the GAO, and they're going to want to do it within 5 days, get that automatic stay, and then they're golden. Next slide, please. Bid protest mistake number 7. This is another one we see a lot, that people are not really sure. They might be sure of everything we've talked about so far. They might be sure when to ask for a protest, but they're not really sure what to ask in a protest, what they're allowed to ask, what they're not allowed to ask, what they will get, what they can expect, what they won't be getting from the government. And also, as part of this, we're going to be talking about the DoD enhanced debriefing regulations, which have caused a lot of confusion amongst contractors over the last few years. So with that, let's dive in. Next slide, please. So the first thing to keep in mind is, what are you going to get in the debriefing? Let's assume you've timely requested it. Let's assume it's a required debriefing. What's going to be included? What information are you going to be able to gather? And it's going to depend on whether you're pre-award or post-award, whether it's the competitive range situation or whether it's a post-award unsuccessful offer notice situation. You get a lot more information at the post-award stage than you do at the pre-award stage. At the pre-award stage, you're going to get the agency's evaluation of significant elements in your proposal, a summary of the rationale for eliminating you from the competition. Again, remember, this comes up in the context where you've been kicked out of the competitive range, and highlighted for importance, reasonable responses to relevant questions about whether source selection procedures contained in the solicitation, applicable regulations, and other applicable authorities were followed. So in other words, this is your opportunity to put together, or work with an attorney and put together, or work with your consultant and put together, your proposal writer and put together questions about, hey, I want more details about what happened here. Why was I eliminated? Why did you make the decision that I shouldn't make the cut for competitive range? And you're really going to want to take a look at, what you know, and try to think of really intelligent questions to get the information you need. Number one, to help you improve going forward. But number two, to gather the information you might need to protest the award decision. Next slide, please. What you are not going to get in a pre-award debriefing is any information about the number of offers, the identity of other offers, in other words, who's in the competitive range and who made it, who else was kicked out. You're not going to get anything about the other offers' proposals, obviously. You're not going to even get a ranking of the other offers, because that probably hasn't been done yet. They've opened discussions with them, but then they're not going to rate or rank them until after they get revised awards or revised proposals, You're not going to get anything about the evaluation of other offers. And then you're not going to get any trade secrets or privileged or confidential or proprietary information. You're not going to get anything that's going to, obviously give you an insight into your competitors' competitive information. Next slide, please. What about on the post-award side? Well, the post-award side, you get a little bit more information. You are going to get the government's evaluation of any significant weaknesses or deficiencies in your proposal. You're also going to get the overall evaluated cost or price and the overall technical rating for you and for the awardee. You're going to get the past performance information about you. You're not going to get that about the awardee. If an overall ranking was done, you're going to get the overall ranking. A lot of times agencies try to avoid doing an overall ranking because they don't want to share that information. So sometimes you'll get that, sometimes you won't. Summary of rationale for the award. And again, I've seen anywhere from that being, paragraphs long to one paragraph or one sentence saying you didn't present best value. If it's a commercial item situation, you're going to get the make and model of the item to be delivered by the awardee. And then again, that same language, reasonable responses to relevant questions. So this is really your opportunity to dive in and ask questions about anything you think might be have gone wrong. Next slide, please. You're not going to get a point-by-point comparison of your offer compared to the awardee's offer. That's just not going to happen. And you're not going to get any of that proprietary information, trade secrets, confidential information, or anything about the bidding information of your competitor, the one that won the award either. So many people are aware of this, but many people don't realize that they have a right to ask questions, and the questions are really the most important thing that you can do to prepare for your debriefing. Come up with specific areas that you think might have had a problem and ask questions about it that are going to be, allow you to kind of determine whether or not there was a problem here that gives you a basis to protest. Next slide, please. On the topic of questions, I want to talk about the DoD Enhanced Debriefing Deviation. This is something that came out in 2018, and basically what it did was say, hey, look, for all DoD procurements where there's a post-award debriefing being given, we think that we really need to make sure that people are being given the opportunity to ask questions. This was happening because people were getting written debriefs instead of oral or telephonic debriefs, and they weren't really getting the opportunity to ask those reasonable, relevant questions. So under the DoD Enhanced Debriefing Deviation, if you are getting a debriefing post-award for any DoD procurement, and by that I mean not just the DoD, but any of its subsection agencies, any of the DoD agencies, anything under DoD's umbrella, once you get a written debrief, you have 2 business days to ask questions. You then get written responses from the government to those questions. And remember, we've been talking about the deadlines to protest. And we've been talking about the fact that if it's a required debrief that you timely requested, you have 10 days from the conclusion of your debriefing to file a protest. The reason that the DoD Enhanced Debriefing Deviation is so great and gives the protester such an advantage is your debrief is not considered concluded until you get those answers. So let's say you get a debrief on a Tuesday, you ask your questions on a Wednesday, and you don't get answers until the following Friday. Government's supposed to do it within 5 days aspirationally, but it's not always done that quickly. Your 10 days doesn't start from the day you got your notice. It doesn't start from the day that you got your written debrief. It starts from the day that you get the answers to your question. So this is really an opportunity to explore those issues you need to explore, get the information, and in the background, start preparing for a protest. It buys you a little bit more time. It's a really, really helpful tool. So in terms of if you actually get a telephonic or an oral debriefing, which are pretty rare at this point, most places give out written debriefings. I would say if you ever have the opportunity to request what type you get, always better to have a conversation, ask and see if you can have it telephonically. But if you get it, usually you're going to get it written. If you have an opportunity to get it telephonically or orally, I would take it. In terms of who should attend, if you get it telephonically or orally, a lot of people think that their lawyer should attend. I actually think that that is not a good case unless the client or the contractor really wants it. I think having a lawyer on the phone or in a room really greatly chills the effect, or has a chilling effect, and really kind of limits what the government is willing to say, and you're going to not get as much information as you normally would. So I actually think that an attorney should help you prep, should help you come up with questions, but should not be unless you think it's absolutely necessary on the phone call or in the room itself. I think the most important thing is getting answers to your questions and then helping your attorney put together arguments later to go into the protest. The debriefing is not where you want to make your arguments, it's where you want to information gather. Next slide. So this is a big one. Don't pursue a losing protest. Next slide. We have a lot of very honest conversations at my firm with our clients about this. Not every protest is a winner. Not every protest is worth pursuing, and there's some questions you need to ask yourself. The first things, jurisdiction and standing, are kind of procedural requisites that you need to make sure you meet, or you're not going to be able to file a protest, or you're going to file one and get dismissed right away. So jurisdiction's a big one. There are differences between a claim and a protest. You got to make sure you understand that this is really a protest, not a claim, or it's going to get dismissed. There are the big one in terms of jurisdiction is the task order thresholds. Under 16505, you cannot file a protest of a task order procurement unless it's over $10 million if it's a civilian agency, or over $25 million if it's a DoD agency. Now, if you're filing a protest basically saying that they increased the scope of the contract, that's a little bit different. But generally speaking, if you're just protesting the task order decision, the award decision itself, you are limited in what you can do unless you are over those thresholds. If you're under those thresholds, you might be able to challenge it with the ombudsman, but you're not going to be able to file a protest. And even if you're over those thresholds, you have to file it only at the GAO. You can't file at COFC, and you can't go to the agency. So if you don't fall within those jurisdictional prerequisites, can't bother filing, it'll be dismissed right away. It'll be a complete waste of legal fees. Also, standing. Not everybody can file a protest or has the right to file a protest. You have to be what's called an interested party. An interested party is defined as an actual or prospective bidder whose direct economic interest would be affected by the award or the failure to award the contract. A lot of times that means you need to show that, but for the error in the procurement that you're protesting, you would have gotten the award. If you are so far below, if there was 13 people bidding and you were the 10th in line, you don't have standing, you're going to get dismissed. Finally, and this is a lot of times the hardest for a contractor to objectively look at, but you need to look at what a win really looks like here. Are you going to be making arguments that are trying to argue with the subjective judgment of the agency? You're a lot less likely to win that than one where you're able to show objectively that there was an issue. Also, are you going to be able to, get the award overturned and then it's just going to go to a different one of your competitors? You really want to take a strong and honest look at, what am I going to get at the end of this? I'm going to get an invoice for my attorney's fees, and unless I think I'm going to get a good chance of the award, it's probably not worth pursuing. I have very honest conversations with my clients. I don't think it makes any sense for clients to throw a lot of money at the situation if it's going to just result in them taking the award away from one of their competitors and giving it to another competitor. I think it's very important to take an honest look at this and make sure that, hey, look, if we go forward with this, it's going to be worth it. I'm going to get the award, or I'm going to at least have a really, really strong shot of getting the award. And that's an honest conversation that you have to have with your attorney in terms of, look, what's my likelihood of success here? Because protests can be hard to win. Next slide, please. Moving on from bid protests and kind of moving to size and status protests, I just want to hit on this point quickly before we wrap up. Next slide, please. You will often hear people refer to protests kind of as an umbrella topic, but it's important to understand the differences between bid protests and size and status protests. Now, these are all challenges that are raised by contractors. Usually it's going to be a competitor to whoever got the award. And they're going to raise a challenge saying, hey, look, this award shouldn't have gone to the person that it was awarded to. So that is something that they all have in common. But the basis of the challenge itself differs. When it's a bid protest, what is being challenged is the agency's source selection decision. So in other words, the protester is saying, hey, the government did not do, what they did was not consistent with the law or was not consistent with the terms of the solicitation. They acted improperly or, in error when going through the source selection process and when making this award decision. The agency failed to comply with the terms of the solicitation or the applicable law, and they made a mistake because of that in who got the award decision. Size and status protests are not challenging anything the agency did. Instead, they are challenges when you got a set-aside contract, which only certain contractors are eligible to bid on. These are challenges to that eligibility. They're saying in a size protest, hey, look, this is a small business set-aside, and you awarded it to small co, but small co isn't actually small, and here's all the reasons that I know that that's true. And a status protest is similar. It's hey, you awarded this contract to this company that says it's an STVOSB company, but I know that they're not an STVOSB company. I know that this other company controls them, or I know that they're affiliated with this other company, and I know that they're not, therefore, an actual STVOSB. They're not eligible, and you shouldn't have given them this award. So these are different types of protests. We've been talking today about bid protests, about how to challenge the procurement decision. But size and status protests challenge the eligibility. They are not brought before the GAO or before the COFC, etc. They are usually brought before the SBA and in some limited cases now the VA. They're under different rules. There's different timelines and procedures and arguments and things that apply. So don't confuse the two. And don't think that it's a one or the other type situation. It is entirely possible to bring both. I've seen contractors come to me and say, first of all, this person wasn't eligible, and here's all the reasons I know that. Second of all, even if they are eligible, here's all the ways in which the government, I think, made the wrong source selection decision, and you file both. You file a size of status protest with the contracting officer, and you file your bid protest with the GAO. Cover your bases. Be aware that all different types of challenges exist and that they're ruled by different procedures and different rules, and they're brought in different forums. And, you know, I see a lot of people come to me and say, I have a bid protest, and what they're actually talking about is a size protest. Or I see people say, you know, I don't think this person is eligible, and it's actually a bid protest issue, not a status protest issue. And it's important to keep those differences in mind so that you can start thinking about the deadlines that apply. Generally speaking, just as an aside, since we're mainly focused on bid protests today, but, you know, for size and status protest enthusiasts, you're going to have to bring those usually 5 days after the day you get a notice that says this is who we're planning on giving the award to. So again, 5 days, very short timelines to file any sort of protest, whether it be bid or size or status. Really important to figure out which deadline you're under. Next slide, please. This is our final point. Now, all throughout this presentation, we've been talking about what you want to do if you are a protester. But what happens if you are on the flip side? If you are, you know, you just got the notice of award and you're happy and you're celebrating and you're high-fiving and you're popping the champagne. This is amazing. We just got this huge contract that we're going to be performing on for the next 5 years. And then 2 days later, you get a stop work order because somebody filed a protest and they're staying the procurement. What do you do? Next slide. I can answer in one word. What you do is you intervene. The protest, yes, is technically against the agency, which means the government counsel is going to jump in to defend against the protest. And that's great. And I get questions a lot of times from my clients, well, why not just sit back and let the government do their thing? Let them defend their own procurement decision. We're not the ones that made the procurement decision. Why should we even get involved? And the reason is because you need to protect your rights. When the protest is filed, your interests are in line and, you know, are in concert with the government's interests. Theoretically, they want to defend the award decision. You want to defend the award decision, so you get to keep the award, and you're on the same page, and great. And it very well might stay that way. Or the government might decide, we might have messed up. We want to take corrective action. We want to go back to the drawing board and reconsider awards. Or they might say, yep, I don't really feel like staying this weekend and working on this, so we're going to take corrective action. I think that's rare, but I think it happens. So you need to have your foot in the door so an attorney that's representing your interest is able to say, hey, look, even if the government starts to back down and says that they want to reconsider this award decision, we're not letting that happen. So the way to do that is to intervene. It's very, very simple to start the intervention process. It's basically a one-page filing. You can get your attorney to do that. You can get your attorney on the docket, able to monitor what's going on. And then if the government continues to have their interests aligned with yours, your attorney can sit back and not incur any additional fees and just tell you what's going on. And you don't have to act and file a lot of things. But you're in the door, you're able to monitor what's going on, and you're able to see if you do have to step up and act. And that's the really important thing. You're in a position where you can be aware of what's going on, know if you've got to do something additional to protect your interests, and then you can do it because you've got the intervention filed and in there. So the biggest mistake on the flip side is that people don't intervene. Don't make that mistake. Don't fail to intervene. Next slide, please. And finally, bonus tip, don't be scared to ask questions. As you can see, there's a lot of information relating to protests. There's a lot of complicated topics, a lot of moving pieces that impact each other. So it's really important, if you've got questions, that you get somebody involved early that's familiar with this process and can guide you through it so that you don't miss a deadline or misunderstand a required debriefing or mistake a pre-award protest for a post-award protest, etc. Don't be scared to ask questions. Don't be scared to engage an attorney early. Don't be scared to reach out to people that can help you with this process. So with that, I know we're out of time, but I'll stick around for additional questions if you want. If you've got questions that we didn't get to today or questions that come up at a later point, next slide, please, you can feel free to reach out to me. All my contact information is on the screen. You've also got my LinkedIn and my Twitter, where I share news stories relating to federal government procurement and small business procurement. Happy to connect on either of those forums as well. And with that, I will turn it over to Scott and Earl.
Great, Maria, thank you for that. A lot of information in a short period of time, but it's such a relevant topic. Just a couple of comments that I had based on what you said. One, I agree with you when you're talking about bringing an attorney to a debriefing. I can't tell you how many times when I was working in the government that I would see the government would totally freeze up, and the response always was, well, you have your attorney, we have to get ours, right? And so that's not something that you want to get into. The other comment that you made that I think is key is the one about intervention, because it's one of the few times when you as a vendor for the government and the government agency can actually work as a team and a partnership to get the ultimate result that you want out of that. So I agree. If somebody's protesting something you're doing, you want to intervene and be as much help to the government as you can. The question I had is this. One of the things that's happened, this is a civilian agencies, not DoD agencies. And when someone asks for debriefing, what they get is a letter. And basically what the letter says is, we made the determination we did because it was in the best interest of the government. And the small business will go back to the government agency, the contracting officer, and ask for more specificity. And many times the government just clams up, doesn't want to deal with it. Have you ever run into that? And are there any techniques or shortcuts or suggestions that you can give to folks as to how you deal when you've got an agency that just flat out doesn't want to give you any information?
Yeah, I think there's two pieces to that. I think the first piece is that when you respond to a written debriefing letter, the more you can show that you know what you're talking about, the more the agency is probably going to say, okay, they know what I am, required and am not required to give them. So if you say, pursuant to FAR 15505 post-award debriefings, I'm allowed to ask reasonable relevant questions, and I'm entitled to responses, and I would like responses on these three matters. And sometimes you can even say, and also I'm aware that, we're not subject to the DoD enhanced deviation, but nonetheless, can you please confirm that you won't consider this debriefing, quote unquote, concluded until I get my answers? And it seems like, most agencies would then say, oh crap, they know what they're doing and they're going to get an attorney involved. But a lot of times that's enough for them to say, all right, they know enough of what they're doing, we can't mess around with them. Now, does that always work? No. And I think the second piece that I want to kind of bring up is, if that doesn't work, then what you do is, and this is something that a guy I used to work with used to say, but sometimes you don't know if you got a protest until you file a protest. And one of the things that you can do is file a protest saying, hey, look, this is what I do know. By the way, I tried to get additional information about this in my debriefing and I wasn't able to get it. And, oh, that's right, you have to now produce the agency record, and I get all of that information anyway. So I think the first thing is to really hammer home, hey, look, I'm sophisticated. I might be a small business, but I know my stuff, and I know the FAR, and I know what I have a right to, and this is what I'm entitled to as part of a debriefing. You better give it to me. And if they still are stonewalling you, then I think you file a protest based on what you have, and you're going to get all that information as part of the agency record. And then you're going to be able to go forward with whatever, and they're going to look pretty bad. And once they get their own legal department in, that legal department's not going to be very happy with them. And I think is going to be more likely to take corrective action, to be honest. But I think those are kind of the stops that we usually pull out when we see an agency trying to stonewall.
Yeah, good advice. Thank you for that. Because from a small business perspective, as you know, that can be terribly frustrating when the agency just wants to clam up.
Yeah.
Also, one of the other questions that comes up all the time from a small business when the issue of a protest comes up, it's, well, I don't want to protest because I don't want the agency to blackball me or blacklist me or whatever you want to call it. Do you see that happen often? Is there a way to detect that? What's your thoughts on that?
No, that's a really good question. We get that question from our clients a lot. They're concerned about that. They're concerned about the client relations aspect of filing a protest. And what we tell them, and what I think is true, is, hey, look, the procurement system is designed to be self-regulating. The government expects protests. Now, that being said, if you're one of those people that doesn't go through that list of considerations that I talked about of, hey, do I have jurisdiction? Do I have standing? Is this just me being litigious, or is this actually going to point out a legitimate error and result in my award, or me, having a substantial chance at award? If you're filing protests left and right, are they going to start rolling their eyes when they get a protest from you? And perhaps that's going to, influence their overall opinion of you? Yeah. But if you pick and choose the legitimate protests you file, it's designed, the whole procurement process is designed to be self-regulating. It's meant that people are supposed to protest mistakes in the procurement process. So I don't think you get blackballed. And I think, frankly, if you do get blackballed and you're able to show that bias, that's a basis for your own protest. But or another protest, I think as a general matter, procurement officials are good people. They're not biased people. They understand how the protest process works, and they don't blackball or hold it against people. But I think that's why it becomes very important not to be, filing protests that perhaps are a little bit just throwing some stuff at the wall. You really want to only go after the legitimate ones.
Okay, good. Thank you for that. Those were the questions that came in from the audience. So you can tell people were paying attention. So thank you for that. And again, thank you for your time, for joining us today. We always appreciate your support. To everybody on the line, I'm sure you found it beneficial. If you have follow-up questions, please get them to myself or to Earl, and we'll get them to Maria. And we'll look forward to being on with you again next Monday, same time, same link. All righty. So everybody have a good week, and thank you again.
Thank you. Bye-bye.